Hello, good afternoon and welcome. My name is Susan Lynch. I am the Associate Director of Lifetime Learning at the University of Virginia's Office of Engagement. We are pleased to welcome you, and I'm eager to learn more right along with you about this important topic of criminal justice and criminal justice reform. Before starting the program, I want to provide some quick housekeeping items. If you have a question during the presentation, you may enter it in the webinar Q&A. You'll find resources in the webinar chat. Please also note this program is being recorded and will be posted in Lifetime Learning's podcast library in about a week or two. I will introduce the moderator and then he will introduce the rest of the panelists. Timothy J. Longo is the Associate Vice President for Safety and Security and Chief of Police at the University of Virginia. In this capacity, he oversees the UVA Police Department, the Department of Emergency Management, Clery Act compliance, threat assessment, and safety and security systems and technology. Chief Longo brings more than 40 years of experience in law enforcement leadership and higher education to this role. In addition to his primary law enforcement and educational endeavors, Longo has served as a part of a team of independent monitors appointed to conduct police department oversight on behalf of federal courts in 3 cities across America. In addition to these responsibilities, he has served as a police practice expert on behalf of both plaintiffs and defendants in a variety of legal matters in state and federal courts pertaining to law enforcement and municipal policy and practice. Most recently, Chief Longo testified on behalf of the government in the matter of the United States of America versus Tao Toe, J. Alexander King, and Thomas Lane, the former Minneapolis police officers who were charged in connection with the death of George Floyd. So thank you again for joining us for this Lifetime Learning program. Now I'm going to turn the program over to our esteemed moderator to start the program. So Chief Longo, please take it away.
Thank you, Susan. I appreciate the introduction. Well, good afternoon, everyone. Welcome to the grounds of the University of Virginia. I'm speaking with you today from O'Neill Hall here on the university's grounds. And I'm particularly proud and honored to be in the company of 2 esteemed colleagues and dear friends with whom I've had the great privilege of working with and knowing for many, many years. It's not often that we get a chance to explore the hearts and minds of 2 such thoughtful and experienced scholars who have a real commitment to this topic of criminal justice reform. So Deirdre and Rachel, I really appreciate you both taking time out of your schedules, from your work, from your research, your scholarship, and most importantly, your families, to spend just about an hour with us to chat about police reform and criminal justice reform this afternoon. Before I begin my questioning, I want to just introduce a little bit about Deirdre and Rachel. And if you've lived, learned, or followed any of our work in this community, you undoubtedly know these 2 people and perhaps know them well. But for those of you who don't, let me take a moment to introduce them. Deirdre Enright is currently the director of the Project for Informed Reform in the Center for Criminal Justice at the University of Virginia Law School here in Charlottesville. She was previously the founding director of the Innocence Project, also here at UVA Law. But before joining the faculty here, worked in the Virginia Capital Representation Resource Center. And after graduating from UVA Law in 1992, she worked as a staff attorney at the Mississippi Capital Defense Resource Center. Professor Enright holds a Bachelor of Arts degree from Northwestern University and a Juris Doctorate from the University of Virginia School of Law. Deirdre is joined today by her colleague and our friend Rachel Harmon. Rachel is a Harrison Robertson Professor of Law and the Director of the Center for Criminal Justice here at the UVA Law School. Professor Harmon moved to academia after serving 8 years as a federal prosecutor in the United States Department of Justice Civil Rights Division. After graduating from Yale Law, she clerked for Judge Guido Calabresi of the United States Court of Appeals for the Second Circuit and the Justice Stephen Breyer of the United States Supreme Court. Professor Harmon's most recent case book, The Law of the Police, was published in 2021 and is the first of its kind, exploring a wide range of laws and policies that govern police interactions with the people that they served. And we'll touch a little bit on Professor Harmon's casebook in just a few minutes. Before we jump into the questions, and for those of you who are joining us, I scripted about 10 questions. We'll try to move through them pretty quickly, but knowing these to folks like I do, it might take us a while. We'll do our very best to get to the questions that you have. Deirdre, tell us about the project for informed reform and how that came about. And I guess most important, at least from my perspective, is what are your top and highest priorities for the project moving forward?
Thank you for the question, Chief Longo. After starting the Innocence Project at UVA 13-ish years ago, it was great work, and it's work that never gets boring or tiring, or and it's important. But I always found myself being at the back end of a problem, right? It was getting a man who's been incarcerated. I think our last clients were in 32 years, 28 years, 22 years, and 20 years. And you don't really have time to sit back and think about how to fix the things that caused those problems to begin with. And there's just a list of 7 problems in the criminal justice system that are associated with wrongful convictions and innocence cases. And so I started brainstorming with Rachel about a clinic that would just research and study problems, not just problems with innocence or wrongful convictions, but I thought about how in practice, you rarely have time to sit down and think about how to fix anything, because all you're trying to do is undo what was wrong. And you never have time to get in front of a problem and study it, and study things that have answers, that actually have answers. There's a lot of problems that I would have to say, I'm not ready to study that. I don't know enough about that. But there's a lot of problems that I know a lot about. And using students who increasingly are smarter than me, to help me think about those problems and to research those problems and to come up with scientific or just actual answers to questions, and then present them, to the General Assembly or to the press or to whoever it is that needs to hear that there are ways to do things that will prevent accidents in the criminal justice system. And so that was the idea for the clinic. And I have to say, having a couple of years to bat heads with Rachel helped me a lot to come up with what I should do and what I could do. So that's my new clinic.
Well, it sounds fascinating to me. You and I have talked about this whole topic of wrongful conviction and the great work that your program and programs around the country have done in this area. I've been involved in many of those cases, several that I've had, one still pending, that go as far back as the John Burge era in Chicago, and all the things that we learned. So much has been written about that era of policing, the lessons learned, and many of those lessons were uncovered because of programs like the Innocence Project and the good work that attorneys like you and others have done to free those who were wrongfully convicted for crimes they never committed. So congratulations, and we look forward to hearing more about the program. Rachel, you worked a long time on your casebook. A lot of research, of effort went into preparing that. I know we talked about it many times over the years, and it finally came to fruition. And exciting that it has. What did you discover along the way? As experienced as you are, and as much as you know about this topic, you undoubtedly uncovered some things in your work that you were able to put in print and now carry into the classroom to make us smarter in this field of policing.
Yeah, actually, I learned a lot along the way. I originally turned to the case. I mean, I started to write the casebook because I'd been teaching in the area, and increasingly professors at other schools wanted to teach policing law as well. They didn't come from that background. That wasn't their area of expertise. And so developing materials for that purpose was my original goal. But as I started to do that, I realized that there were no resources for practitioners, for sophisticated people who want to know more about the law governing the police. The resources out there were very, very exclusively focused on constitutional law, and in particular the Fourth Amendment and maybe Miranda. And that was such a narrow window into the kinds of law that influence what police do all day. So my goal was to take a step back and incorporate a focus on state and local government action and the range of kinds of laws that influence policing and influence police encounters. And then as I was finishing the book, George Floyd was killed, and the increased attention to problems in policing and the sustained public scrutiny of what policing looks like in this country led to a flurry of legislation at the state level and a flurry of policy action at the local level. And so incorporating that and thinking through, it really confirmed to me that what the approach I was taking was the right one, but it also presented all sorts of new material and new opportunities to think about how public safety is produced. It's been fascinating. I think if you said what was one thing that surprised me, no, many things surprised me, but one maybe was I started with the idea of what does policing and police encounters look like? And then let's look at all the law that influences it, as opposed to starting with the Fourth Amendment and then asking how does that restrict policing? And that made me realize my approach that there are big areas that are important to criminal justice outcomes and important to people's experience of policing that are largely unregulated by the law. And I think I had focused on those individually over the years, but never really thought much about that. And one is the use of informants and undercover agents, which is largely unrestricted by state law, by local policy, and certainly by constitutional law. And the other was the interviewing of witnesses, the ways that, and this is something that Deirdre sees a lot in her work, and we've talked about over the years, the ways that officers interview both witnesses as well as suspects, which is more heavily regulated, really influences the quality of the evidence and therefore the justice we get, again, largely unregulated. And so those are some of the lessons I learned. Deirdre's actually been using the book as a resource. So it's meant for students, but she's been using it so she could tell you about the book.
I should actually say too, Rachel, you should know this. I claim credit for many of the chapters. I tell students that I wrote them. Anyhow, and Rachel just brought something up that's one of the things that has come up in the clinic, and it's something that I would like to work on as a problem. But so police generally use the Reed interrogation method, and Chief Longo, I invite you to do do a little show for us on that here and now. But it's really what all police departments use. And there's this other manner of interrogation or questioning that is much more like what we used in our clinic, and it's called the peace interrogation method. And it's designed to ask open-ended questions. And part of what we teach students is, if you're doing all the talking, then you're not interviewing. And so you should just have the goal is to develop a relationship with whoever you're talking to, whether it's somebody who you believe is antagonistic to your case, or friendly, or whatever. You're just trying to get them to tell you information, and no information is irrelevant really in that method. And it does take a long time, and it takes a lot of patience, but you learn things, and you don't plant information inadvertently or advertently in the witness or in the person you're talking to. And to me, it yields much more relevant and pertinent information without suggesting information. And how I'm going to get the United States of America to accept that is something I will now begin to study.
Well, I think the door of acceptance has opened. It's opened over the past several years for a variety of incidents, a variety of kinds of cases, and the marriage of these two brilliant minds into this space, in this place, at this university, I think will further advance what we do here and the good work that we do in the area of criminal justice. This topic of criminal justice reform has presented itself in so many different ways over the past couple of years. People have said, well, let's reimagine policing. Well, what is that? Let's deconstruct policing. Well, what does that look like? Well, police reform, what does that look like? I mean, it's so broad and expansive, it's hard to really drill down and get some concrete and substantive meaning of what that exactly is. And so I'll ask you, because you're the experts, what does criminal justice reform look like in your view? And I guess more importantly, how does it impact the work that you do, and how will that work translate into the student body and then come out into the field of criminal justice? And Rachel, why don't I start with you, and then we can toss it to Deirdre.
Chief, I think you could answer this question better than either of us, but since you've asked it, I'll try to make a go of it. You could correct me. But from my point of view, there's no one in this country who does not want to live free of fear and violence and doesn't want justice done when serious wrongs are done to them. But our system for achieving those goals often goes astray, and we punish too often, too much, and deeply unfairly. And the racial and social and economic consequences of that are vast. So the Center for Criminal Justice helps connect professors who are studying and working on a range of criminal justice issues, from bail and juvenile justice reform to racial disparities and mass incarceration. But my work is almost exclusively about policing. Although I helped found a nonprofit here that's focused on reentry issues, my research and my work with nonprofits and governments is mostly about policing and how the law influences police and could do so better. And our goals are to make policing more effective, but also less harmful, more democratically accountable, more racially just, and treating people with more dignity and respect.
Deirdre,
Go ahead, Tim.
can you top that?
Oh, God, yes. No, of course I can. While Rachel was talking, I was thinking, just what my day was like today, to me, is the sign that our ways of approaching problems have changed dramatically and radically in the time I've been doing this work. And so it used to be that I never had discussions with prosecutors, and I never had conversations with police enforcement officers that were willing, that everyone wanted to engage in. And I never talked to the press because you couldn't control what the press was going to say. And there were the clinical people, and they were different from the academic people, and ne'er the twain would meet. And just today, I've talked to two different prosecutors who were saying, I have problems and I want you to help me solve them. Let's work together. You can come to my office. I can come to your office. I called a law enforcement officer with an idea about how to solve a crime he was involved in that the wrong person went to jail. And he was like, great, let's do it. Let's come. I'll come to your class. I'll meet with you. I also talked to somebody in the press who said, I've heard you've got a theory about a case in Maine. I want to hear about it. Will you talk to me? You know, like the lines of communication seem to be wide open between people that used to be diametrically opposed. And what is even more heartening to me, and I don't like to be heartening or positive or hopeful about anything, but it seems like we're all listening to each other, right? It seems like I get to say things, and people who used to think I'm just going to dismiss anything she says are saying, oh, okay, let's try that. And I even find myself where students will say, well, why don't we do it this way? And I start immediately saying, yeah, we don't do it that way. Here's why we don't do it. And then halfway through my explanation, I say, that's a really good idea. We should probably do that. And so they have ideas that I've never heard anyone say we should try, and they're great ideas. So that to me is like, it is one of the many things that's happening is that people are talking to each other and listening to each other, and in a way that's really hopeful. At least it looks that way to me, and I'm pretty jaded and bitter.
No, I think you hit it on the head. I am hopeful as well, and I think Rachel is. And I do a lot of work in this space. You both know that. Most people don't. A lot of my work never makes it above the fold. It's only when I fall and skin my knee that it does. I've learned a lot over the years, and one thing I've learned is you got to be intentional about this business of, you call it what you want. I really don't care whether we call it reformation, deconstruction, reimagination. It makes no difference to me. As long as we agree, we all want the same thing. We want a community that's safe. We want people that are treated fairly when they become part of the criminal justice process. And we want communication between both sides of that room, both sides of that V, both tables in that courtroom. And it has to be intentional. The goal to get to the right place, which is justice, has to be intentional for both sides. The other thing I think is important is the recognition that it's more than just the rule of law. And that's an odd thing for a bunch of lawyers to say, but I've learned in my lifetime as a cop, it's really about balancing the rule of law with public policy that meets the expectations of the people that you serve. And if I've learned anything in my career and continue to learn, it's that. And I think that will start to be reflected in police policy and police practice. rather than just rely on what the Supreme Court says about the Fourth Amendment, look at the Fourth Amendment, examine the return on investment for the practice that implicates it, and then decide whether it's what's best for your community. I think that will be one way in which to get to this reform, whatever that might look like. Deirdre, your work over the past several years that we talked a lot about, it's really caused you to focus on people that were harmed in ways we can't even imagine. You've read any stories about people who have been wronged in wrongful conviction cases, whether they became the focus of an investigation because of someone who narrowly focused through tunnel vision on the wrong person, or whether they became the product of a criminal conviction because of some fabrication, or in some cases even torture. You've seen a lot of that in your cases. Of all those things, it seems to me that the very nature of your work have caused you to identify what some of these critical problems are in our system. Can you talk a little bit about some of those problems that you've identified? And I guess more importantly, how are we working towards, to the extent we can ever eliminate a problem, eliminating them from this criminal justice process, whether it's being through how we train cops, how we train lawyers, how we educate citizens, whatever the case may be?
Right. Well, yes, that's a great question. In the innocence world, we basically say that there are 7 red flags for wrongful convictions, and they are police and prosecutorial misconduct, junk science, bad eyewitnesses, bad defense attorneys, false confessions. There's more, and that when you are, and then there's little signs like if a case is tried twice, we often think, that's usually a problem, something went wrong, and so, not that there's one solution to any of those problems, but those are red flags for problems. And so for false confessions, over time, we've realized that you need to record those interrogations because it's protection for the police that they did not feed details or pressure or push or abuse somebody, but they're also an opportunity for a defense attorney to say, maybe you didn't know it, but you did feed details, and maybe you didn't know it, but you did make him feel that he had no choice but to confess. So there's things like that. There's eyewitness identification, also a big problem. It's, I think 75% of innocence cases have a false identification problem. And now in some progressive states, you get to have a pretrial hearing and you get to test those identifications, and they have to meet criteria. And if they don't meet them, they're not coming in at trial to, skew the verdict. There's big areas that need a lot more work, which is the police and prosecutorial misconduct, because, not turning over exculpatory information was probably in, every case we ever did in the clinic. There's almost always some Brady violation. And it doesn't matter if a prosecutor did it on purpose or didn't do it on purpose. It's whether it's advertent or inadvertent, it's a Brady violation. And so having open file policy would help us solve those problems. Nobody would have to worry about making a judgment call because we would have open files. Jailhouse informants are becoming increasingly less a problem because states are saying you can't use them in capital cases, or they're saying you can only use them if you have a hearing about it before, or you have a cautionary instruction for the jury. Because the problem, people always say, oh, jailhouse informants, who believes them? Well, the problem is you're not usually on more than one jury or in a long period of time. And when you watch somebody swear that they're telling the truth and they're getting nothing for their testimony, and they look believable, then you think, well, this guy's probably pretty good. You don't know that in the world, that's what everybody says. And then they are getting something in, So there's long ways to go on all of those 7 issues, but there's also there's been a lot of progress since I started practicing law, a lot of progress. There's a lot more to go, but people are increasingly seeing that those 7 areas are problematic. And even if they don't result in the conviction of an innocent person, there are still constitutional violations that are happening in cases where it's still a wrongful conviction if you did it by violating the Constitution. And, we need to have, I think, a lot more, especially in Virginia. The state is done with your case when your direct appeal ends. And so, all the cases that we were able to show that someone was innocent, it was just because they were lucky enough to rise up our queue of hundreds of people and have a bunch of really active students looking at them. It's not because someone's systemically going through cases and figuring out who was wrongfully convicted, because we're not. And the number of innocence projects that exist in this country, which I should know the answer, I think it was 43. That should be troubling to anyone, that we need that many innocence projects in this country. And those people are just doing the surface of the problem. I'm going to turn it over to someone more positive. Rachel?
Let me ask 2 follow-up questions if I can real quick to come to one. One is a clarifying question. The other one is more opinion. The clarifying question for the non-lawyers, explain what a Brady violation is.
Yeah. So when you have a criminal case, the prosecutor has to share, depending on what state you're in, certain files. But you have a constitutional obligation, exculpatory information beyond whatever your rules are in your state. And so Brady violations are when the state or the Commonwealth attorney withholds a document, either on purpose or accidentally, that you could have used to prove your own innocence or defend yourself. And so like a great example is, in one case we had a prosecutor did not turn over the fact that when he was interviewing witnesses for his case, he was bringing them all together in a room so that they could hear what each other said, and as he said, iron out the details, right? So what he was essentially doing was orchestrating testimony and saying, all right, we're going to go with your version here and this guy's version here, and you're not allowed to do that. And the defense attorney was never told that that was what was happening. And of course, he could have cross-examined endlessly about how they came to say the things they said. So that's a Brady violation, holding evidence that you could have used as the defendant at trial.
Question about eyewitness identifications. From time to time, we'll send out information to the community that says, hey, a crime just happened. And oftentimes we'll get criticized because of the suspect description of that might be so de minimis, so scant, that it would be harmful to release a white male, black shirt. How does race play into eyewitness descriptions? How helpful is it to say whether a person is white or black, particularly when there are no other descriptors like clothing or something that's more definitive than other characteristics might be, immutable characteristics?
Right. So it's funny that you bring that up, because when you in your position have to put those out, I think that every time I read one, I think, how could I possibly take that description and say anything productive or helpful? Now, I guess if I lived in the area where something happened, and I could say, well, I looked out my window at 2:14 a.m. and I saw somebody who looked like, then we would all go get our Ring doorbells looked at, and we would perhaps find something relevant. What adds into it is how terrible we are at cross racial identifications. So, I mean, we do exercises within our clinic of identifying people even within our racial group, and we're pretty terrible eyewitnesses, period, right? Like we think we're so attentive, right? And we think that we're more attentive when a crime is happening. And in fact, if it's a dangerous crime or a crime that involves a weapon, we're worse. That's what the experts are saying, right? When you're in fear or in danger, you're not paying attention to what you think you are, but you're not. So then if you add the racial component, we become even worse. And I think, so one thing I think we don't accept about ourselves is that in general, we just aren't paying that much attention. And we all think that we are. And we don't understand that every time we think about what we saw, we change what we saw. So we just don't have much of a healthy skepticism of our own foibles as witnesses. And if you do in school exercises about it, you do learn that we're not that great. I often think, when I see somebody drive by me, I'll think, what did I see? What did I just see? And I really don't, I'm not really paying much attention. So I don't think I answered your question. I think I compounded it and made it worse.
You know, that issue, Deirdre, that you're raising, which is that we're not always good at knowing what we don't know or knowing what we're good at and aren't good at, comes up throughout the criminal justice system. It comes up with prosecutors and their screening of cases. And it definitely comes up with police. If you ask police officers and prosecutors, actually, they will tell you that they know who's lying. The research shows that they don't know who's lying, but every prosecutor and officer I've ever met thought that they could tell. And that leads to a kind of sense of confidence that makes us sometimes get it wrong. And so I think that self-consciousness about what we can't do well is really important in the system.
I think so too. And the fact that wrongful convictions or bad identifications are 75% or so of the wrongful convictions suggests to me the less than value added aspects of a suspect description. More often than not, those alerts go out to tell you there was a problem in your community, not so you'll go out and try to find the suspect. Rachel, I want to turn, if I can quickly, you know, somewhere between those of us who studied or have studied this issue of police accountability, somewhere between the Wickersham Commission of the 30s to these modern day commissions that look at various police departments that are under judicial intervention from the Department of Justice. If you look back at all of them, and there are these common themes that just keep coming up over and over and over again. Can you talk a minute or so about what those common themes are? But I guess more importantly, how do you take those themes and operationalize them in a police department through everything from policy to training to supervision to get at the heart of what perhaps police reform might look like in the 21st century?
I think that's a really important question. When we think about policing, what officers do on the street, the question is, well, if we want to change what officers do on the street, how do we do that? And the answer is that we do it through departments. So every officer in this country, there are no free-range police officers. Every officer works for a department, and those departments set the expectations and incentives for those officers. And you can think of policy and training and supervision and discipline as the primary ways that departments set those expectations for officer conduct, enable officers to meet the expectations, and then impose consequences to help align officer incentives with the agency and public expectations for officer conduct. And without that kind of internal accountability within departments, I think it's very hard for us to ensure that policing on the street is consistent with the law, is consistent with community values and priorities, because it's really that chain of between the chief's expectations and what an officer actually does that creates accountability. But the inside of departments, that you could think of that as a form of internal accountability. Well, that's only one side of the equation. Then the other side is something you raised earlier, which is the public needs to weigh in on how policing actually affects the community and what it wants public safety to look like. And there are a range of ways that the public does that. But whatever we do inside departments, it has to be responsive to what communities need, what they want, and how they're experiencing the policing that they're getting. And that means there are opportunities for the public to weigh in a range of, I mean, a complaint to a department about an officer contact, that's a way of weighing in, and smart departments treat it as information about how their policing is being perceived. But obviously the public weighs in at budget meetings and by electing officials who share their vision, by marching in the streets even. Those are all ways that the public sets up the expectations and the community values that then policing should be responsive to. But unless we have that system of internal accountability, and it's got to be all working together, policy, training, supervision, and discipline, if that's not all going in the same direction, then we're not going to be able to influence officer conduct in the street in the way that the community wants.
How effective are judicial remedies? And we read about the Justice Department marching into a city or town when things go wrong, and they do an investigation. Sometimes you hear about the outcome of it, sometimes you don't. But I think that aspect of our law that goes back to the 90s, as many of us know, really was intended to provide some kind of remedy. I think. How effective is that remedy?
So the law that you're talking about is the law that authorizes the Justice Department to conduct pattern or practice investigations, which is to say to investigate police departments to determine whether there's a pattern or practice of constitutional violations. And you and I have both worked on some of those cases. So we've seen them a little bit up close. First of all, you have to think of that law in the context of other remedies for police misconduct. When a police officer violates constitutional law, they can be sued, but there are a lot of obstacles to those suits, most famously qualified immunity that limits plaintiff's ability, victim's ability to get compensation or to deter future harms. Officers can be prosecuted, but as you know, that's rare, and it probably should be relatively rare because that's for the most egregious cases. There are lots of constitutional violations that don't amount to criminal harm. What the Justice Department's investigations do is give a chance to say, they're forward-looking. The idea is to prevent future constitutional violations by going into a department that is resistant to change, or sometimes has just gotten on board the project of reform, and help them identify the causes of constitutional violations and start building the systems of internal accountability that will help prevent them in the future. Those are expensive. As a result, investigations, they take a lot of time, and as a result, they're relatively rare. And so while I think they are an important tool for helping to fix some departments, I also think that we shouldn't overestimate the Justice Department's ability to influence policing across this country, because they've only investigated about 75 departments in the 20 years, now almost 30 years that the statute has been in effect. And there are 18,000 police departments in this country. And so while I think it's important, and the Biden administration has turned the lights back on in that program after a break under the Trump administration, I think we should also be realistic about what it can achieve.
I have to ask you both a question. Since you've both worked on those in the groups that go in and look at a police department, both in a resistant police department and in a police department that's welcoming of the assistance, how much difference does the manner of welcome make in what you can do for them?
I'll jump in first and simply say it really depends on the leadership of the community, the governing body, the mayor, the council, the county executive, and the leadership of the department. I've worked in departments that were highly resistant of judicial intervention. And I've worked in departments that have opened the door and said, make us better. That department will matriculate through that process much quicker and much more effectively than that department that crosses their arms and says, there's nothing wrong with us. These processes can take a few years to more than a decade, and they're at the expense of the taxpayer. That's who pays. The taxpayer in that community is who pays for that judicial intervention. And those people that come in to monitor those consent decrees or memorandums of agreement, they don't work for the Justice Department, and they don't work for that community. They work for the judge who was assigned that case at the very beginning. And that's who they report up to. And it really is up to that judge for whether they get to that point of compliance that we can turn the keys back over to them and say, now go run your department. It really depends on the leadership. I don't know whether Rachel's had a different experience or not.
No, I agree entirely. I think it really does depend on the leadership. But I think people underestimate how hard reform is. Even a committed department, it's really hard to do this right. Sometimes people will say to me, the reason we should abolish police is because we've tried reform and it hasn't worked. And I think that's like saying we've tried democracy and it hasn't worked. I'm not saying that policing is perfect today. And I think re-envisioning how we produce public safety in this country is absolutely critical. But I do think we are likely to continue to have some form of coercive policing, and reforming it is very, very hard. And so when we go into a police department and start saying you should do this kind of training and this kind of policy, if it's resistant, it's very likely that you'll walk away at the end with a department that is only superficially better than it was at the start. And there's nothing anyone can do to by magic make it better. But I do think that these efforts often result in a significant impact in departments, changing the culture of departments, and changing their relationships with the communities. Not everywhere, but in many of them. And I think that is, as many things in policing are, a lot having to do with political leadership.
I agree.
Thank you.
Again, opinion, probably more than anything else. What do you think the role of the legislature is advancing some of these concepts of police reform? We talked about the statute that empowers the Attorney General of the United States to bring the cause of action against a municipality to hold them accountable for constitutional harm. What is the other ways in which legislatures, if at all, should have a role in reforming, changing, advancing, deconstructing, call it what you may, policing?
I think Deirdre's already specified some of the ways that, and she could talk more about the ways legislatures can prevent the things that go wrong in the criminal justice system. But in terms of, and in particular in trials, in policing, legislatures set the hiring and training standards for police departments. Should the age be 18 or 21? They authorize and limit police practices. So can police use facial recognition software or chokeholds? They allocate funding. So they decide whether to fund surveillance tech or community violence prevention programs. Locals do that too, but both at the state level and local level, that's a legislative act. Legislatures, again, local, state, and federal, determine how much information we know about policing, what's collected and what's available to the public. Do we have access to data on traffic stops or uses of force or body-worn camera footage? And then lastly, legislatures determine the legal remedies and how available they are for police misconduct. So which acts are criminal and whether officers are going to have qualified immunity when victims sue.
Right. And I can add to that, so we only, at the Innocence Project, we only relatively recently started having a policy group where they would analyze the problems and then take them to the legislature. So pretty recently, we were able to change the law so that what you could get through the Freedom of Information Act was more information. So it used to be that we couldn't look at closed cases. They would say, well, there could still be an ongoing investigation. And we would say, wow, that's weird because my guy's in prison for that crime. So how is that an ongoing investigation? And so it wasn't hard to make the case for, in those cases, we should be able to look at the files. And we were able to get cities to have to tell us, in one case, Richmond told us that, yes, this police officer has a 72-page disciplinary report. We won't give it to you, but it exists, which we can then, if we need to, possibly go to a court and say, all right, can we have that? So, and we changed the writ of actual innocence to include cases where someone pled guilty, because in 25% of innocence cases, people have pled guilty and they plead guilty because they've been threatened with something worse. And so you do plead to things you didn't do and you confess to things you didn't do. So those were all good and pretty quickly reformed. Now there's a different group in power in our General Assembly, and some of those are all already being disabled, those reforms. And so, that's the other problem, that as quickly as you can reform it, you can unreform it, not completely, but significantly. So yeah, we were able to do some good things at the General Assembly, and now we get to watch them be undone.
What do you think the role, Deirdre, what do you think the role of the judiciary is in this? I mean, the judiciary gave us this whole notion of qualified immunity, right? It's nowhere in the Constitution. Looked all through the Constitution, I can't find it. It was a judicially created thing.
Right.
What's the role of the judiciary for helping to fix some of this stuff?
Well, I think I'm in the wrong group. I don't think my answer here is going to be satisfactory, but I do think that and Ketanji Brown Jackson just suffered this. A lot of our judges were former prosecutors and Commonwealth's attorneys. And I would argue that you could read the transcripts in the Innocence Project and see that prosecutors get deferred to on a regular basis by the courts, and that they're presumed to be telling the truth, and they are presumed to have the better information. And now, again, I suspect that that's probably something that's changing, but a lot of the problems is the lens problem, right? Is that if you were a prosecutor and you become a judge, and you're a hammer and you see nails, and that's what happens. And the things that defense attorneys have presented, I mean, one of the Innocence Project cases was a case where the guy who actually did the shooting came to the trial and sat on this witness chair and said, I did this, it was my gun, I was the person. And the court found that it was the defendant who was being accused. And so the problem with that case is, how do you have new evidence to bring in later for us, right? Because that was the evidence. And now every other reviewing court will say that was seen before by a judge and he decided it was nonsense, and that person said for 21 years, I did that. So, it feels like the presumption of innocence is just really, it's just something we like to say. And it's reinforced by having judges who are often prosecutors. And I hate to end on that note. So Rachel, say something positive.
Chief might have another question. Otherwise, we could talk about what we're doing at UVA to prepare people for this.
Well, I do, but I have one more question, and this really comes out of in the interest of time, comes out of the question and answer box, but it strikes me as being particularly relevant now. We've heard over time this blue wall of silence as an obstacle to police reform. It gets in the way of the work that's been done in the Innocence Project. It surfaces in the work, Rachel, that you and I have done in various places. Two-part question. How do you overcome that if we're going to be successful? Can it really be broken down? And then the second piece, the second piece of that, I guess, is if we look at these various departments that we know or have an understanding of having problems or issues, are there common characteristics among those departments? And is this code of silence one of them?
Yes, so those two questions I think are closely related. The idea of the code of silence is a real one. As you know from your experience, officers rely on each other, and it's important to build trust, but that can turn corrupt or toxic when it comes to covering up conduct that really should be revealed, and lying to prevent misconduct from coming out. I think one of the shifts that you've seen now, and actually your work in the Tao case, I think helps to show this, is that we're starting to focus less on the officer what an officer does, or changing an officer's actions after misconduct at trial, and starting to move it back to say, actually, officers have a responsibility to step in before or during misconduct to prevent us from ever getting to that point. And that shifts the conversation from the code of silence to the code of action, which is to say, you're not, and not just for you and not just for the person that an officer is interacting with, but for the officer who is going astray themselves. Officers stepping in are protecting each other when they prevent wrongdoing from happening. And so that shifting focus on prevention is part of is a new way. It's not that it's totally new. There's always been this obligation, but we're starting to think about that, to train it, to implement it in policies, to implement it in state laws, to create a duty to intervene that is part of the same ethical obligation as that duty to tell the truth after the fact, but takes place at a much earlier stage when officers can rely on each other to help prevent things from going off the rails. So I think that's a shift in focus that's actually quite important, and that maybe leads us away from the exclusive focus on the wall of silence. And then the question of, well, are some departments more likely to engage in problematic behavior, and in particular that blue wall of silence that in which officers are lying to cover up bad acts by other officers? I think yes. And I think that comes in part from insular communities, insular departments that don't have enough new blood flowing through them, or departments where the leadership, where that chain between the chief and the officer on the street is frayed, so that officers are really acting in units that are unaccountable, that are unsupervised, that aren't integrated. And we have a lot of strategies for actually preventing that insularity. So one is diversity in departments, and people coming from different perspectives, different backgrounds, different races, different sexual orientations, different everythings. That helps break up those insular subgroups in departments. Also ensuring that that we don't have groups that are unaccountable, that answer only to a sergeant that's not integrated into a broader set of accountability measures in a department, are other ways that you can prevent those things from happening. So I don't think they're inevitable. I think they are a matter of policy as well as a matter of culture. And those are things leadership can influence.
I couldn't agree more with that. Yeah, and some of our more recent cases, the one that you had just mentioned that I was most recently involved in, the impact of those cases will have long-term historical effects in policing reformation, probably more powerfully than any other cases had in recent history, and how that will play out in state court is yet to come.
I think I couldn't agree with that more. I mean, as someone who used to prosecute police officers, that was a case that would have been unimaginable 10 years ago. I think that because most of the duty to intervene cases involved, or cases where officers didn't intervene, were only when supervisors didn't intervene. We did not emphasize the role of peer intervention the way we are now. And that case has highlighted the issue in a way that I think it's not that it will lead to many more prosecutions, but it will lead to policy change and departments to take seriously the training and policy around intervention, which I think will change the culture of policing.
So, I want to look again briefly to some of the questions in our chat. And one question, and it's a question that comes up probably in every conversation with public officials and policing officials around policing. And that is, what is your position, if you choose to have one, on this notion of defunding or abolishing policing, right? Taking it apart and doing something else to accomplish the same mission. Rachel? So
I think it's, as I mentioned earlier, critically important to rethink how we produce public safety, so that we are not relying exclusively on policing to create safe and thriving communities. And that has to involve a whole range of efforts. And I think stepping back and thinking of policing as one tool of public safety rather than the tool of public safety is important. So if the question is, should we be rethinking public safety? I think the answer is yes. And I think we're starting to do that and do the research necessary to figure out what works. Communities are doing it at a local level in ways that I think are imaginative, and many of them are yielding really good results. But if the question is, should we abolish police departments or starve police departments as a way to discourage bad acts, I'm not sure that's likely to work. I think defunding focuses on moving resources from policing to other avenues of public safety production. And I think that's an important question, but it's not about defunding the police. It's about looking at the most effective ways of dealing with public safety. And, gun violence and public safety is an equity issue too. 100,000 people in this country suffer non-fatal gunshots each year, and 2/3 of them are African-American. And I think we should see the public safety gap as one of the worst racial disparities in this country. That doesn't mean the answer is more policing, but it does mean that we have to think about public safety as opposed to starving police departments as a solution to these problems.
Deirdre, shifting gears just a little bit and going back to what you talked about with respect to interviewing. Do you, when you're talking to your students in the Innocence Project, and perhaps Rachel in some of your classes with respect to the law, the police, do you cover any trauma-informed practices that might be specifically important when it comes to interviewing? And I'm especially thinking about victims as well as the interrogation of or interview of a suspect.
So we treat interviewing and interacting with victims entirely differently than we do any other, if it's particularly if it's a sexual assault or rape crime, something like that. So we say, first of all, we tend to tell people, you're going to go to the person's house and you're going to knock on the door. We're not calling ahead. We're not doing any of that because it's much easier to hang up the phone than it is to close the door. And especially if you've got two 23-year-old law students that are fresh-faced and eager and have notebooks. But victims, we deal with much differently, and we write letters ahead of time and we ask them if it would be okay if we could talk to them, and we go to whatever setting they want and we talk in whatever forum they want, and they can tell us whether they want only women to come or if they only don't want women to come, or so we do it very differently, and whoever it is that goes has to read extensively about that kind of a crime and the different, but I also have to add that one of the cases that I worked on many, many years ago was a crime where my client had been convicted of raping and murdering his mother-in-law. And I was supposed to, somebody told me to talk to some of the siblings because they thought that those people might not have wanted the death penalty, but that didn't get out there. So I wrote letters. I didn't get an answer. I went one day and I just left a card on the door and just said, I stopped by. I don't know if you want to talk to me, whatever. And I was so glad they weren't there. I can't tell you how happy I was driving back to my house. I was an hour away when I got the call and they said, turn around and come back. How dare you leave a car? You come back here right now. And I thought, this is going to be the worst thing ever. And I went back and they had a gun on the kitchen table and I was told to sit in a chair, and the victim and his victim's family, screamed at me for about 4 hours. And I just kept saying, you're absolutely right. I have nothing to argue with you about. And he was, how dare you, how dare you, how dare you? And ultimately, he became one of my best friends. He would show up with his wife on Christmas morning for 6 years at 5 a.m. to bring presents to my children. He was opposed to the death penalty, but he had been shunted out of the system by both the prosecutor and the defense attorney. So no one ever listened to him. So all he needed was somebody to scream at. And I was that person because I showed up. And then after you let somebody scream at you, then you say, okay, how can I help? And we helped each other. So I've found victims have been some of the most powerful allies we had, but it took many, many terrible, terrible interviews and interactions where you just have to listen and do nothing else, but they've been incredibly helpful.
It's a great story. Rachel, one last question. We have about a minute and a half left. How are you going about, your classes fill up every semester and lots of students look up to you and listen closely to your lectures. How are you preparing them to participate in this topic, these debates around police reform? What are the tools that you're giving them to add value to these discussions moving forward?
Well, I'm just one piece of a bigger puzzle at UVA, which is a wide range of courses and clinics that help prepare criminal students for criminal practice and also for participating in debates around reform. Increasingly, my students are not only ones who want to be criminal defense attorneys or criminal prosecutors, but people who are just interested in participating. And my casebook and the courses I teach on the law of the police are intended to help prepare them for that, but so are our defense clinic, our sentence reduction clinic. We have a new decarceration clinic, juvenile defense, Innocence Project, prosecution clinic, civil rights clinic, as well as all of the traditional criminal law, criminal procedure courses. We have courses in race and criminal justice. Deirdre and I, a prosecutor and a defense attorney, teach a course in a seminar in criminal reform. There's just a range of opportunities for us to engage in our students and for them to hear a wide range of voices on these issues. And I am optimistic in a way that and maybe some people aren't. The majority of the public continues to think policing should get better in this country. We've got more sophisticated journalism on policing than ever before. And I think there's a generation of students and law enforcement leaders who are committed to making policing and criminal justice better. And I think we'll get there.
Well, what a way to wrap up. I want to thank you all for sitting with us, spending the last hour to talk about this important point of discussion and topic, not only in this community, but throughout this country. What an honor and a pleasure it's been to be with such talented colleagues. I wish you a great day and thank you for being with us today.
Thanks.
Back to you.
So thank you so much to each of our panelists. This was such an interesting, important, and rich conversation. And I always learn so much from our faculty, and it sparks my curiosity to learn more. So I certainly hope that that is true for all of you. I want to take a moment and bring some upcoming lifetime learning programs to your attention. On Tuesday, April 12th, I'm hosting an in-person event at the Mariners Museum in Newport News. I hope you'll consider joining me for the behind-the-scenes tour of the museum's exhibit and their conservation labs of the USS Monitor, which was a Civil War battleship that sunk off the coast of North Carolina. We'll be going into the labs and viewing artifacts for this battleship, so it should be a very interesting day. The program sold out this morning, but we do have a wait list, and we hope to have other folks join us. So please consider looking into that. Also, keep your eye out for an upcoming virtual event on Wednesday, April 20th from 3 p.m. to 4 p.m. We'll have a program entitled 50th Anniversary of Apollo 16, the Penultimate Lunar Mission. We'll be joined by Edward Murphy, who's a professor of astronomy from UVA's Department of Astronomy in the College of Arts and Sciences. So to check out our lifetime learning programs, the podcast library, and our UVA Speaks podcast series to watch and listen to our UVA expert faculty, you can find all of our lifetime learning events and online resources at our website at engagement.virginia.edu/learn. So thank you so much again for joining us. Please stay safe and be well. And I hope that you enjoy the rest of your afternoon. Thank you so much.